Check 1, 2. Hello, hello. Welcome. This is going to be Just Human episode 360. And for those of you who got the original episode 359, this is going to be the other half of that episode, which I've now removed from most places, plus a little bit more. What happened, if you're not familiar, after I put out the original version of episode 359, which was very, very long, I realized that for some reason, when I processed the video, it cut off the final 15 minutes. And while I was fixing that and making a new version of it that I was uploading everywhere, news broke in the J5 pipe bomber case that I wanted to add on to it. So I ended up just making episode 359, a new version of it that was only focused on the J5 pipe bomber case. And so this is going to be the other half of the episode it is now focused on Richman v. United States. And this it feels appropriate. I'm going to go ahead and address something because one of my longtime listeners brought it up with me, and it's probably worth explaining. So you guys, because I'd mentioned in the previous episode in the intro to it, I'm really liking the workflow that I'm in now and the way I'm doing these episodes and the way I'm making videos. And it's just way better. It's way better for me as far as my voice goes, and way better for me as far as the process of research, the process of recording videos, and the process of putting videos out. And one of the key changes that for you might be a lot different, but for me is just made this huge difference, is that what I used to do is I would record my podcast episode, and it would be typically 2 hours plus. And then after I'd recorded it, I would then go through and make clips of it. And then I would put those clips out as individual videos. Or I wouldn't, and I would just say, screw it, I'm not going to make any clips. And the reason is because it's so freaking time consuming to go back through the podcast and make clips from it. And it was just not, I've never enjoyed the process, and it's always just taken so many hours to go back and just get a 30-minute clip. And there were always things I missed, and I would forget where I wanted to make a clip, and people would request clips from the episodes, and I appreciate that because it would help me find them and determine what people wanted. But this change I've made where I record the segment first and then stitch those together to make a podcast episode, plus adding an intro, adding in some other tidbits into the podcast, that works way better for me. One, it results in me actually ending up making more videos. And then two, it doesn't eat up near as much time. It's saving me hours and hours of sitting at a computer doing work. And so that's opening up a time frame for me for this other thing I'm going to do, which you'll find out about soon. So I'm really it's just working so well for me. But I can also see how those of you who have been listening for a long time, it's kind of confusing because there's videos that I'm putting out that are 15 to 30 minutes or so. And then that same video will wind up in my podcast, and then you're faced with listening to something you've already heard. And so that's why I'm putting timestamps in everything. So just to bring everybody along, I'm making all these videos, and then in my podcast, down in the description, whether it's on Substack or it's on Rumble or YouTube, I put these timestamps down here so that you can navigate in the video to where it is you need to go to catch the latest thing. Like in my in episode 359, the revised version of it, I didn't have the final 50 minutes with the judge's order detaining Cole and not getting any pretrial release. So if you already watched these videos, but you hadn't seen that, you can just skip to that. And that's the new piece. Now for people who only really consume my podcast and they do so via Apple, Spotify, or justhuman.substack.com, then you may not have been aware that I've made this change at all. But for people who are consuming my videos on YouTube and Rumble, you become aware that I'm putting out these shorter videos, and then a podcast will land that has some of the same videos in it. So now I've kind of like brought you guys along on what I'm doing. And I hope that makes sense. Uh I hope that makes sense to y'all. Um I'm not saying it's the best way to do it, but I am saying it's a way that's working out for me where I end up making more content, and I'm more reliably uh putting stuff out and having multiple videos on these topics. Uh so if I think I wish I would have started this way. The reason I didn't was because I used to only do live streams Monday, Wednesday, Friday, and then afterward would try and get myself to make clips. But it was just so many more hours of work, and so dull doing it, and I hated it. And so I wouldn't do it. I wouldn't make near as many clips as I should have. But now this way I end up making them. So I'm open to your feedback on it, though. Like, the whole reason I'm bringing this up is because I know that there's lots of you, thousands of you, who listen to my stuff or watch my stuff, whether it's on Substack or Rumble or YouTube. And I'm interested in your feedback, and I appreciate it when you give it to me, especially when it's it's thoughtfully delivered. And I want to know what it is that you're listening or watching for, so that I can deliver to you what it is you're here for. I've been stuck on some of these cases and just doing real document research. And since I took a holiday break, uh, I need to play a little bit catch up. And then we have some new stuff, which of course is that Nicolas Maduro has been captured. So that gives us, oops, I didn't switch back to this. So that Nicolas Maduro has been captured, right? So that gives us brand new material to cover. And the cases are old, but the indictment is a superseding indictment, and that's new. So I'm going to start there with that. And what I'm looking at right now is, like, I'm keeping tabs on the United States v. Comey, the appeal there, Richman, J5 pipe bomber, Maduro I'm going to cover, and then we got the Osif Merchant trial coming up in early this year, just in, I think, next month. And we have the Antifa terrorism case, and then whatever ends up happening with these grand conspiracy cases, grand conspiracy grand juries that have been impaneled in Florida that start now. They start next week or this coming week. We'll see what happens with those. All right, so here I am at the beginning of this video. What I'm going to do is, one, thank you all for being here, and thank you for listening to me prattle on about the back end work that I'm doing on these shows and just like my thought process. And I'm asking you for feedback on it. I'd love to hear your thoughts or suggestions, whatever. And now we're going to go to what's up next in the Richmond v. United States coverage. And I think that'll be this entire episode. I don't think there's going to be room for me to add on anything having to do with Maduro yet. But I already have one video out about Maduro. The next video I'm going to put out about him is me going over the indictment, and then we'll see what else it brings. So, all right, a bit of an odd beginning to this podcast episode, but I felt like there was some house cleaning type this conversation or monologue that needed to happen, and I also felt it fair for me to go to you guys and say, hey, give me some feedback on what you think about the way I'm putting the shows together and putting out videos right now. Yeah. So there we go. All right. I'll see you. Gotta stop that. You'll see me in the video or something. I don't know how to transition to the next segment, but let's go. Hey folks, I'm back with another update in Richmond v. United States. Where we left off last, the Judge Colleen Collar-Catelli, had ordered DOJ to file the Arctic Haze search warrant materials that were taken from Professor Daniel Richman. She ordered DOJ to give them back to Professor Richman, but to also make a copy of all of those materials and file them under seal in the Eastern District of Virginia. And that would allow, one, Richman to get the relief that he's seeking in this civil case. Two, DOJ would retain a copy of all the materials, and they would be under seal in the Eastern District of Virginia, where they would presumably, DOJ wants them so they can use them in a future case against Comey or whoever. And DOJ would be able to get a new search warrant, which is what they should have done earlier this summer, or at least apply for a new search warrant for the materials, get what they wanted out of those materials, and then use it against some future indictment of Comey or whoever else, right? And it seemed like a win-win, to be honest. It seemed like Richman was getting what he wanted, but DOJ was not being deprived of those materials that they gathered during the Arctic Haze investigation some 5+ years ago. And they weren't losing access to them. It was just going to be under seal, and they would have to get a judicial search warrant in order to get material from them, which is what they should have done anyway, like I said. So that was document number 20 on this case. Okay. That was the judge's order right here. And it came with a memorandum right here, which further went into detail of it, which I have not gone over with you guys. And that's what I'm going to do in this episode. But before I go over it, I want to tell you that since then, on December 12th, there's been some 20 more filings in this case. They did not go on Christmas vacation. In fact, there was an emergency motion on Christmas Eve. So things have not slowed down here at all. And DOJ has not quite complied with the judge's order. And Professor Richman has not quite received the relief that the judge granted him. So things in this case where we kind of left off in the last video, it seemed pretty straightforward and simple. Like, hey, that's a resolution that makes sense and is also intriguing because it allows DOJ to go on with whatever investigation they're wanting to do, or they're wanting these materials to contribute to, whether it's an indictment of Comey or there's some other thing going on, which I happen to think there's probably some other thing going on. It seemed like we were set up like that was it, but that has not been what has happened. At the same time, Comey has not been re-indicted by DOJ, and instead DOJ has appealed the decision that killed United States v. Comey. And I have it. Here we go. So they filed a notice. I want to see what date it was. It wasn't Christmas Eve. It was just before. There we go. Notice of appeal was on December 19th. So almost a full month after United States v. Comey was dismissed, DOJ has notified the court that they are appealing that case. And I found the docket for the appeal. It is right here. It's the Fourth Circuit Court of Appeals. And we have a schedule for it. It was docketed December 22nd. And I believe filings are due by January 17th or 26th. January 26th is when the opening brief is due. Response by February 17th. And then a brief reply within 10 days of that if they're going to file a reply. So looks, who knows if they're going to wait to the last minute or if they're going to file an extension for it. But this path of appealing the judge's order, which was always a possibility that they would appeal the dismissal of United States v. Comey, and they said that they were looking to appeal it. I actually figured they wouldn't. The quicker and more obvious path, it seemed to me, would be maybe not more obvious. This is just as obvious. But it seemed to me like they might just re-indict Comey and just bring a new case with a new prosecutor or in circumstances that resolved what the case was dismissed for, and just do it all over again, like a fresh start to it. Just a redo. And I don't think it would be successful because of, what is it, 18 USC 3288 or whatever it is. Because I don't think that they can actually bring the case again. Because the statute of limitations have expired. But that would be another battle that they would go into, right? Doesn't mean they wouldn't try to. They would just have to deal with that. So that's the path I thought they would take. But instead, they've gone for an appeal, which is going to take even longer and it's going to push us even further past the statute of limitations, which lapsed back September 30th of this year. So this is a much longer road. And at the same time, you also have Richmond v. United States, which at this moment has these materials that they seized from Richmond back in the Arctic Haze investigation. It has them kind of not in limbo, but they're at issue in this case. And I really don't know why. I've thought about this over the Christmas break, which, by the way, Merry Christmas to all of you. Hope you had a good one. I had a good one myself. I don't know why they didn't tell this judge that we're right now working with these materials and they're at issue in a different case, and we want to expedite this, get it under seal and resolve it, and then that way we can get a search warrant for the materials and use them in this other case. Instead, they've gone this road where they're kind of playing a game over here. And I don't mean to diminish what they're doing, but there's a very like chip, like it's not quite a chess game. I suppose it's fair to call it a chess game, but it's like this tit for tat incremental legal maneuvers here on this docket with all these. There's several motions for clarification on little bitty details, and I think the judge is getting quite fed up. So anyway, we're going to get back to the Richmond case. I've kind of gone off. These things are connected, so I haven't gone off trail, but it's difficult to. One of the things that one of the reasons why I haven't done a video in the past like 10 days, besides it just being the holidays and wanting to enjoy that and all, is because this has gotten not convoluted, but there's so much information that you kind of need to have in mind at the same time to grasp the situation with this case and with the Comey case and then now the appeal, that it's a lot to take in, and then to try and put it back out and represent it is a task. It's not as straightforward as it initially began as, which I'm not too surprised about that. So anyway, Linktree is in the description, and it's also in my profile wherever you're watching or listening to this, and there you can find all the places to follow, watch, listen, and support the show. Thank you to everybody who has supported the show over the course of 2025. Really appreciate you guys, and I look forward to 2026. And yeah, let's get to this. So where I want to go, this is the order that I went over back on December 12th is when this came out, and it told the government that, hey, you seized all this stuff. You seized material from Columbia University email accounts of Professor Richman and his Apple iCloud account, and you also got his phone and his PC, and these are collectively called the covered materials, and you are ordered to return those things. The motion for return of property filed by petitioner Daniel Richman is granted. The United States is also ordered to prepare a single complete copy of all of those covered materials and file it under seal in the EDVA, where it can remain for future access pursuant to a lawful search warrant and judicial order. And it's ordered that the government shall return to Mr. Richman all copies of the covered materials, except for the single copy that is going to remain deposited with the court. And it's ordered that the Attorney General shall comply with this by Monday, December 15th. Some 10 plus days ago. Now, in her order, her memorandum that went along with this, she takes the time to go through it much greater detail. And I've gone through this a couple times, but I haven't made a video about it. I skipped over it in order to get to some of the briefer filings. But in this video, I want to spend some time here. And one of the reasons I do is because all the rest of the stuff that happens on this docket since then, these are continue to reference the docket order over and over and over again, because that's the big issue here, that they've made this order. And it's not that It's not that DOJ is so much rejecting her order. It's that they're filing over and over again for clarification. And then now on December or on Christmas Eve, a motion for an extension for a stay, for an extension of time. Not stay, an emergency motion for an extension of time in order for them to comply. And Lindsay Halligan continues to be on the filings here for the EDVA, even though she is not, or for DOJ, even though she is no longer the qualified attorney for the district. Which, by the way, I don't think she's going to win an appeal. They recently gave up on Alina Habba. I think DOJ's in the wrong. They're in the wrong on this interim appointment thing. That's another reason why I don't quite get them appealing it, because they're going to lose. They're going to lose. Okay. As promised, the judge's redacted memorandum. Okay. When the government violates the Fourth Amendment's prohibition on unreasonable searches and seizures by sweeping up a broad swath of a person's electronic files, retaining those files long after the relevant investigation has ended, and later sifting through those files without a warrant to obtain evidence against someone else, what remedy is available to the victim of the government's unlawful intrusion? A fantastic question. That's what's happened here. I hope everybody realizes this. That what DOJ did, you please set aside your opinion of Comey. Set aside your opinion of Comey and everything. Just set all that aside. It is a fact that DOJ during Arctic Haze, that those investigators took more from Professor Richman than what the search warrants authorized them to seize. They took more than what they were supposed to take. They took from a longer timeline than they were allowed to. The window, each search warrant said from anything fitting the description of the search warrant materials it was aimed at, and that exists between this date and this date. And they went outside of that. They went broader and deeper than what the search warrants allowed them to do. That's infraction number one. Infraction number two is that they seized attorney-client privilege materials from Richmond. That's infraction 2. Infraction 3 is that they did not segregate those things from the materials they were actually after. And they never did segregate them until just now. They had them mixed together for 5 years. Infraction number 4 is that they never went to the clients that were in those attorney-client privilege materials and allowed them to go through a filter process to assert their rights over those materials, their privilege over them. Infraction number 5 is that they did not get a new search warrant to go through this material when this summer they opened up an investigation into Comey. Infraction number 6 is that they used material seized from Richmond pursuant to an investigation that was to do with the taking and transmitting of national defense information, and then use those materials or that they took from here to indict another person for completely different crimes, for obstruction of Congress and for a false statement to Congress. That's what DOJ has done here. And if you can set aside who these people are, you can set aside your own bias, whatever it may be, for or against Comey, for or against Richmond, for or against, like just forget the hearing, forget everything in the United States v. Comey, and just a person's electronic files. Government keeps them for 5+ years, misuses them, doesn't segregate them appropriately, doesn't arrange them to protect attorney-client privilege, and then later, without your knowledge, goes through those materials without a new search warrant to obtain evidence against someone else who happened to be your client, communications between you, an attorney, and your client, and then uses those to indict someone. What remedy is there for such an unlawful intrusion? Federal Rule of Criminal Procedure 41G provides one such remedy. A court may order the government to return the files to their rightful owner. This case calls for that remedy. Petitioner Richman, Daniel Richman, an attorney and law professor, challenges the government's retention and use of certain files that the government copied from his personal computer and online accounts between 2017 and 2020 in connection with investigations of potentially improper disclosures by James B. Comey, a former director of the FBI. Petitioner Richman argues that the government's ongoing retention and use of these files violates his Fourth Amendment right to be free from unreasonable searches and seizures. He therefore asked an order directing the government to return the files to him. Petitioner Richman also applied for a temporary restraining order to limit the government's ability to use the files at issue while this matter is pending. This court partially granted the petitioner's application for a temporary restraining order to preserve the status quo as it awaited a formal response from the government. And I think that's what most people know about this case. I think what most people, casual news observers, and maybe somewhat active news junkies, probably like yourself, what most people know about this case is that Richman, person 3 from the Comey case, Comey's friend, who Comey leaked through, allegedly, went to a judge in D.C. and got that judge to restrict DOJ from investigating his friend. And got a temporary restraining order. Grrr, what a mean judge, what a crooked judge. Grrr, what a crooked person Richman is. Grrr, how crooked Comey is. And that's basically the extent of what people know about this case. Grrr, the court system is protecting Comey. It's all deep state. But we know a little bit more, don't we? Because we're going to the documents. The government has now appeared in this case, and it opposes Richman's request for a return of property and moves to dissolve the court's temporary restraining order. The government argues that Petitioner Richman's motion amounts to nothing more than an improper collateral attack on the investigation and prosecution of Comey, and that return of the property to Mr. Richman is not an available remedy. Not just that it shouldn't happen, but that this is not a remedy that's an option for him. He literally legally can't get it. Upon consideration of the party's submissions, the relevant legal authority, and the entire present record, this court agrees with Petitioner Richman that the government's retention and use of his files has violated his Fourth Amendment rights. And this is not the first judge to see it this way. If you follow United States v. Comey with me, then you know that. Specifically, the government's retention of an image, meaning a forensic image, of Petitioner Richman's personal computer, that is a complete copy of all the files stored on the computer, including backups of his phone and tablet, and its retention of related materials from his online accounts for years after the conclusion of the relevant investigation, is an ongoing unreasonable seizure. This seizure is unreasonable because the government's warrantless search of the files earlier this year reveals that the government has not implemented effective safeguards to protect copies of files from unlawful access while they remain in the government's custody and control. That's what I was going off about earlier, the infractions. The court also agrees with Petitioner Richman that the government's conduct reflects a callous disregard for his constitutional rights, and each of the other prerequisites to this court's exercise of equitable jurisdiction to order the return of property are satisfied. Because Petitioner Richman is entitled to the return of his property as a remedy for the violation of his constitutional rights, the court is unpersuaded by the government's contention that his motion must be denied based on its potential collateral effects on the investigation and prosecution of Comey. In other words, the government can't sit here and say, but judge, if you stopped us from illegally accessing or improperly, to put it more kindly, accessing these materials we shouldn't have in the first place and using them to indict this person that we didn't properly investigate either, it's going to mess everything up, judge, so please don't do this. It sounds silly, honestly. Like, no, you can't. You shouldn't have had it in the first place. You shouldn't have used it in this way. You went about this whole thing wrong. You went about the entire thing wrong. You put a never mind. I'm gonna stop. Accordingly, to remedy the government's violations of Petitioner Richman's Fourth Amendment right against unreasonable searches and seizure, the court shall grant his motion for return of property, order the government to return to Richman the image of his computer that was made in 2017, any files obtained from his Columbia University email accounts, or his Apple iCloud account in 2019 or 2020, and that are in the government's possession, or any copies of the images or files obtained from Richman and his iCloud account, any materials directly obtained or extracted from those files that are in the government's possession. Those are going to be called collectively the covered materials. In order to protect access to the files at issue and preserve their availability for lawful use in later proceedings, and as an exercise of the court's equitable discretion to fashion a remedy that is appropriate under all circumstances, the court shall further order that before returning the covered materials to Petitioner Richman, the government may create one complete electronic copy of those materials and deposit that copy under seal in the Eastern District of Virginia, which shall have supervisory authority over access to this material for future access pursuant to a lawful search warrant and judicial order. The U.S. EDVA may then exercise its discretion to decide whether to allow Petitioner Richman an opportunity to move to quash any such warrant before it's executed. I don't think this is splitting the baby. I think this makes the most sense for everybody. Okay. And then he gives us some background, which we already know the background. I do believe there was something here that was new. And there's this there's this redacted portion here. It says, after this hearing, it's talking about June 2017 when Comey testified that he asked a friend to share the content of a memo with a reporter. After the hearing where Comey testified, Petitioner Richman allowed the FBI to create an image, meaning a forensic copy of his hard drive, all the files on his personal computer and a hard drive attached to that computer. So it's not just one hard drive, it's two. It's the personal computer's hard drive and then an external hard drive, which included backup files containing the contents of his cell phone and his tablet. Petitioner Richman authorized the FBI to use that image for a limited purpose. Okay. We haven't seen what the agreement was. Considering this wording right here, there's something that was signed. There's some document that says, I, Daniel Richman, permit the FBI to such and such and such. And within that document, it describes a limited purpose that they can use what's on that computer for in that hard drive. And then we get this redacted section. We don't know what it says, but there's a footnote. The footnote says, the factual material in this paragraph and the latter half of the preceding paragraph was provisionally filed under seal. If that material is later unsealed, the court will unseal this portion of its memorandum opinion. Very interesting. We will be looking for that to happen. Okay, then it goes on to talk about 2019 and 2020 investigation. So remember, this is something that's kind of easy to forget or overlook here, is that the government got a forensic image of Richman's PC and external hard drive, not pursuant to a search warrant, but pursuant to an agreement with Richman. He volunteered it. And this was part of the DOJ looking at memos that Comey had sent out after he had been fired. That is separate from Arctic Haze. Arctic Haze comes about in 2019 and 2020 in connection with the government's search for who leaked national defense information to the New York Times and other outlets. And when they were looking for that, they went to Mr. Richman, and that's where they had the 4 search warrants. Okay. The rest of this we already know from the Comey case. I'm just going to assume that anybody watching this video paid attention to the United States v. Comey. If you didn't, I have a playlist for it. Let me see. So, yeah, I don't think I need to go back over this material with you guys. Actually, I've changed my mind. Because as I've read further into this, it gives a description of some of the search warrants in Arctic Haze that we haven't had before, or at least are worth stating again. And this judge has seen the Arctic Haze search warrants, and she's describing them here. And I think this is going to become. I think there's a very important thing to understand here, which is, should the government try to re-indict Comey on the same charges, it's going to fail again, because they shouldn't have access to this material, because it is attorney-client privileged, and it was unlawfully searched by the government over this past summer. So it's just another way in which the case against Comey fails, and that they mucked it up. Whether you think that was purposeful or not, they mucked it up. All right, so this says, in April 2017, a major newspaper published an article where, this part, this is the New York Times, where they said that a major newspaper published an article that allegedly included classified information about a factor that influenced Mr. Comey's decision to announce publicly that the FBI closed its investigation into Hillary Clinton's use of a private email server during her tenure as Secretary of State. This article quoted Richman by name and identified him as a confidant and friend of Mr. Comey. Soon after this article was published, the government began an investigation into the public disclosure of the allegedly classified information that had been included in the article. The FBI called this investigation Arctic Haze. In connection with this investigation, between August 2019 and June 2020, the FBI and the U.S. Attorney's Office for D.C. obtained 4 warrants to search Petitioner Richman's electronic files and communications. The first warrant, issued in August 2019, authorized a search of the hard drive containing the image of Petitioner Richman's computer that the FBI had made in 2017. The second warrant, issued the following month, authorized a search of 2 Columbia University email accounts that Petitioner Richman used. The third warrant, issued in January 2020, authorized a search of Petitioner Richman's Apple iCloud account. The fourth and final warrant, issued in June 2020, authorized a second search of the hard drive containing an image of Petitioner Richman's computer. And you see right here, it has Petitioner's Exhibit D, Petitioner's Exhibit B, all of those. Those are these right here, filed under seal by Richman. Those are the search warrants, I believe. And you may recall that in United States v. Comey, it was ordered that those search warrants be unsealed. It would appear that did happen. But they're filed here, or at least they actually, I shouldn't say that. I don't know that happened. I feel like if they had been unsealed, we would see those here. Instead, they're also sealed in this case. Anyway, all 4 warrants were limited in scope to allow seizure of only information relevant to 18 U.S.C. 641, 793D, and E, criminal statutes concerning the theft and conversion of public records and the mishandling of national defense information during specified periods. Petitioner's Exhibit A, which is this right here, which is that first search warrant, limits the seizure to information, quote, to information that constitutes evidence and or instrumentalities of violations of these statutes right here, which are not what Comey was charged with in United States v. Comey. Petitioner's Exhibit B is the same description. Petitioner's Exhibit C, the third search warrant, same thing. It limits the seizures to information relevant that constitutes evidence of violations of these statutes here. And then Petitioner's Exhibit D says it limits seizures to, quote, data and information that constitutes fruits, evidence, contraband, or instrumentalities of violations of those same statutes, which again are not the statutes that Comey was charged under. One of these warrants also contains an express limit on how the government would use the information seized. The first warrant, authorizing a search of the image of Petitioner Richman's computer, provided that, quote, after determining which information is within the scope of the information to be seized, under the terms of the warrant, the responsive information may be copied and retained by the United States. But information that was not within that scope of the warrant would be sealed, and the government would not further review the information absent a court order. Uh-oh. What did they do this summer? They did exactly that, didn't they? They reviewed it without a court order. Petitioner Richman asserts, and the government does not dispute, that the image and online accounts targeted by these warrants contained a trove of personal and professional information related to the Arctic Haze investigation, some of which was highly sensitive and highly personal. Among other things, the materials included a significant quantum of attorney-client privilege information, involving multiple clients. Recognizing the potential privilege issues, the government allowed Petitioner Richman to review warrant returns for 3 of the 4 warrants to assert claims of privilege, but not all 4. With the assistance of counsel, Petitioner Richman reviewed these returns, withheld privilege material, and produced privilege logs to the government. However, for 1 of the 4 warrants, the first one, which authorized a search of the image, the forensic image of his personal computer, the government did not give Mr. Richman an opportunity for such a review. Richman was therefore unable to assert claims of attorney-client privilege over this material at the time the government collected it for use in the Arctic Haze investigation. In addition to privileged material, the image and online accounts that the government collected in the Arctic Haze investigation included sensitive correspondence related to student and faculty appointments, Richman's personal photographs, his personal medical information, and all of his application data. Collectively, these materials are, quote, a complete record of Petitioner Richman's electronic life up to the date of the seizures. The government closed the Arctic Haze investigation in 2021 without filing any charges. In September 2025, 4 years later, in the course of a new investigation into Mr. Comey, led by the FBI and U.S. Attorney's Office for the Eastern District of Virginia, the government conducted a further search of Petitioner Richman's files. Inexplicably, the government did not seek or obtain a new warrant for this search. For this search, an FBI agent was instructed to review a Blu-ray disc that contained a full Cellebrite extraction and reader reports for 2 of Petitioner Richman's devices to identify conversations between Richman and Comey. The U.S. Attorney's Office for the EDVA advised this agent that the FBI was legally permitted to review the information contained on the Blu-ray disc. It appears from the record that there were no precautions in place to avoid the collection of privileged communications during this initial review. During that review, the assigned FBI agent found text messages between several people, including Mr. Comey and a Michael Garcia. The agent did not recognize some of the names, including Garcia, and could not determine whether the messages were relevant to the FBI's investigation of Mr. Comey. Nonetheless, he printed the messages for another agent to review and returned the Blu-ray disc to that agent. Upon review of these printed messages, the second agent concluded that Michael Garcia was an alias for Petitioner Richman, and he determined that some of the messages between Petitioner Richman and Mr. Comey may be covered by attorney-client privilege. About 2 weeks later, on the day that the government presented its case against Mr. Comey to the grand jury, the second agent provided a, quote, limited overview of the messages between Richman and Mr. Comey to the lead FBI case agent assigned to the case and an attorney from the FBI's Office of General Counsel. The agent also advised lead case agent and the OGC attorney that some of the messages between Professor Richman and Mr. Comey that the agents had reviewed, quote, appeared to reference potential future legal representation. There should have been like alarms going off right then. Alarm. The OGC attorney immediately advised that any of the text messages referencing potential future legal representation should not be part of the indictment preparation. After this discussion, the lead case agent proceeded into the grand jury and testified as the sole witness in support of the pending indictment against Mr. Comey without waiting for a filter team to establish or for the privilege issue to be otherwise resolved. 18 days later, after the grand jury voted to return a true bill on 2 of the 3 counts the government had presented, the government approached the U.S. District Court of Virginia to propose a filter protocol for materials that the FBI case team had already reviewed. A story of screw up after screw up, right? It's terrible. I mean, it's almost like the person running the investigation and running that prosecution had never been a prosecutor before. Okay, we can skip this part. Analysis. Although no party contests this court's Article 3 jurisdiction, the judge goes over it anyway, which makes sense because this might get appealed at some point. That might come up. I don't know. Next part. To obtain the return of his property under Rule 41G, Petitioner Richman must show the property seizure was illegal. Richman contends that the government's seizure of his property violated his Fourth Amendment rights in at least 3 ways. 1, the government exceeded the scope of the prior warrant. 2, he argues the government has continued to retain his materials for an unreasonable period of time. And 3, he argues that the government executed an unreasonable, warrantless search of the retained property. The court will address each of Richman's arguments in turn. The court concludes that although the government's initial seizure of Richman's property and its continued retention of that property did not violate Richman's Fourth Amendment rights, the government's warrantless search of his property in 2025, approximately 5 years after the initial seizure, did violate those rights. The court further concludes that the government's mishandling of Richman's property renders its continued retention of that property an unreasonable Fourth Amendment seizure. Huge. These are huge findings by this judge. And they would prevent, I mean, they kill the chance of re-indictment of Comey unless the government can get a new search warrant for those materials. On the present record, Mr. Richman has not shown that the government's initial seizure, it wasn't illegal back then. And Richman doesn't contest the validity of the four search warrants. According to Richman, the government violated the terms of the search warrants by failing to identify and segregate responsive data. Richman's claim of overseizure is based on recent findings made by Magistrate Judge William E. Fitzpatrick in the United States v. Comey case. The court adopts Magistrate Fitzpatrick's findings from the record. Boom. Remember those 11 findings? I have a video going over that in United States v. Comey. And the videos on Rumble and on YouTube, where I go over each one of those findings that are absolutely horrible for the case anyway, for DOJ. Let's see. Magistrate Judge Fitzpatrick's findings establish a reasonable basis for Petitioner Richman to challenge the government's seizure of his property. Yeah, this is good information here. We already know there's other findings from previous video, but right here, this judge makes a really good point and raises an issue that hasn't gotten a lot of attention. Magistrate Judge Fitzpatrick's findings show that Petitioner Richman's former attorney wrote a letter to the government claiming that the DOJ had informed Richman that its seizures under the Apple warrant and one of the hard drive warrants contained property that fell outside of the temporal scope permitted by those warrants, meaning they took more, like it had, remember I said it had a date, material existing between this date and this date, and they went beyond that by months. If this is true, then the government would have exceeded its scope of authority under those warrants. Furthermore, Magistrate Judge Fitzpatrick provided the government with multiple opportunities to dispel concerns regarding its seizure under the warrants. But rather than offer any insight into the scope of its seizure under the warrants, the government simply said it did not know whether the responsive materials were separated from the non-responsive materials. Meanwhile, counsel for the defense reviewed the materials seized by the government and informed Magistrate Judge Fitzpatrick that the manner and format in which they were provided did not reflect the separation of non-responsive materials. Because the government has the most insight into its own execution of the warrants at issue and has not been forthcoming with respect to the information seized from those warrants, the court shall take the government's failure to augment the record as further support of Magistrate Judge Fitzpatrick's findings. So they still haven't corrected for this. They're just not admitting it, is what's going on. They're just not admitting that these materials, that they messed up. They're not admitting that they messed up with the original search warrants. They messed up by how much they seized, the depth and the breadth of what they took. They're not admitting that. They're not admitting that they messed up by not segregating it. They're not admitting that they messed up by not giving due attention to the attorney-client privilege materials and separating those. They're just acting as if they haven't been asked about it. How many times I'm going to hit my microphone this episode? A lot. Okay. The court determines that, or the court shall not determine whether Petitioner Richman has conclusively established a violation of his Fourth Amendment rights, however, based on his claim that the 2019 and 2020 search warrants at issue were overbroad. Magistrate Judge Fitzpatrick's findings raise a substantial question. Blah, blah, blah. The court notes his ruling is limited to this ruling here is limited to Petitioner Richman's claim regarding the government's alleged overseizure of information. This ruling in no way undermines the court's analysis of Richman's Fourth Amendment claim. Accordingly, the court concludes, based on Magistrate Judge Fitzpatrick's findings and the present record, Petitioner Richman has shown a reasonable basis for his claim that the government violated its Fourth Amendment rights by seizing more material than was authorized by those 4 search warrants. However, because the parties have not supplemented the limited record with additional information regarding the government's seizures in 2019 and 2020, the court shall refrain from making a conclusive determination as to whether these seizures exceed the scope of their warrants. So she's saying that I don't have enough information from the parties here about the material seized, about the search warrants, so I can't make that determination. But I can make the determination that the petitioner has shown a reasonable basis for that claim. Okay. Let's see. This is about the government not protecting the files, which they didn't. They didn't. Okay, so these rules about how the government is to maintain and protect evidence they seize. These rules are often relatively straightforward to apply in the context of physical property, but their application can become more complex in the context of electronic data. To what extent does a person have a possessory interest in copies of electronic files if other copies saved elsewhere remain available? When does the government retention of those files interfere with that interest? There are two prior decisions from the district that provide helpful guidance on this issue of whether and under what conditions the government may reasonably retain and use electronic data seized under search warrants issued in a previous investigation. In summary, the Fourth Amendment does not categorically prevent the government from retaining data under these circumstances, but the government must obtain a search warrant before returning that data in a subsequent investigation. And that is where they messed up big time in United States v. Comey. She goes through some other decisions, which are interesting, but we get it. Okay, applying everything above in those court cases, the court concludes that it was reasonable for the government to retain Richman's files after it closed the Haze investigation, but only so long as the government adequately protected those files by refraining from accessing or searching them without a warrant. Although the government's initial seizure of these files swept up a significant volume of material that was not responsive to its investigation, seizing and retaining all of that information was reasonable considering the practicalities involved in the seizure and forensic analysis of digital data. That seizure did not become unreasonable because of the conclusion of the government's investigation, so long as the government had a legitimate purpose for retaining Richman's files. However, given the exceptionally sensitive nature of the files, Richman maintained a possessory interest in them, including an interest in exercising the right to exclude by deciding who could and could not access copies of them. Richman did not relinquish that interest by consenting to limited searches of the files in 2017. Remember, when there wasn't a search warrant, he disagreed. Yeah, you can make a copy of my computer. On the contrary, the government, or the carefully circumscribed terms of his consent to those searches, which we haven't seen that document, but she's describing them as carefully circumscribed terms, that he was actively asserting his right to decide who could access the files and on what terms. After the government closed the Haze investigation in 2021, the strength of the government's interest in retaining the files diminished, but it was not categorically unreasonable for the government to retain the files, so long as the government maintained appropriate safeguards against improper access, which obviously they did not. Most importantly, the government could not reach the retained or search the retained files without obtaining a new warrant, which they failed to do here. So long as the government respected that critical limitation, its intrusion on Richman's possessory interest was limited, and retention of the files was reasonable. However, the situation changed meaningfully when the government conducted a recent search of Richman's files, as the court discusses in the following section. Okay, the government's warrantless searches, or warrantless review of the files, whatever you want to call it. Same thing. The core of Richman's claim in this case is his undisputed and unrebutted charge that the government recently conducted a warrantless search of his files in furtherance of a new investigation of Mr. Comey in the Eastern District of Virginia. Specifically, the record shows that in September 2025, the government directed one of its agents to review a full extraction of the data from Richman's cell phone and tablet to search for messages that Richman exchanged with Comey. Although the government, in a single footnote, broadly, quote, denies that there has been any violation of the Fourth Amendment, it has presented no substantive argument that this warrantless search of Richman's files was consistent with or even cognizant of his Fourth Amendment rights. Recognizing the extraordinary scope and sensitivity of data available on personal digital devices, the Supreme Court has commanded that officers must secure a warrant before conducting a search of data stored on cell phones, except in rare cases in which exigent circumstances make a warrantless search reasonable. Moreover, it is well established that the government seeks, or if the government seeks to conduct, wait a minute, no, that's not what it says. Moreover, it is well established that when the government seeks to conduct another search after it has finished executing a previous warrant, it generally must secure another warrant. These requirements reflect familiar bedrock Fourth Amendment principles. Searches conducted outside the judicial process without prior approval by judge or magistrate are per se unreasonable under the Fourth Amendment, subject only to a few specifically established and well delineated exceptions, which those don't apply here. In short, the government's warrantless search of the contents of Richman's cell phone and tablet in September 2025 was manifestly unconstitutional. Another huge finding by this judge in this order. The government's unlawful search of Richman's files in September 2025 falsifies a core assumption of the general rule that the government may retain copies of digital devices after closing an investigation. The critical assumption is that the government will maintain such files with effective safeguards against warrantless searches. The government's faithful adherence to the warrant requirement is the essential element that protects an investigation subject from general unrestricted rummaging through the immense trove of information stored on digital devices. If the government cannot be relied upon to prevent such invasions, its retention of the subject's digital data significantly intrudes on the subject's possessory interest in protecting that data from unlawful and unwanted access. At that point, its retention of a subject's data is properly analyzed as a Fourth Amendment seizure. The court must therefore consider whether the government's failure to protect Richman's files from warrantless searches makes it continued retention of those files an unreasonable seizure. Under the circumstances presented here, the court concludes that it does. Another huge finding. In sum, the court concludes that Richman has shown that in September 2025, the government conducted an unreasonable search. It was a warrantless search of his files. The court further concludes the government's retention of Richman's files amounts to an ongoing unreasonable seizure, and therefore the court agrees with Richman that the government has violated his Fourth Amendment right against unreasonable searches and seizures. And so they order the court to return that property to him. Okay, let's see if it says anything else about, anything else of interest to us. A lot of this is, we already know it. We know it from United States v. Comey. But another judge looking at this, it just shows how the judges in United States v. Comey got it right as concerns these facets of the case and Richman's property and the government's use and violations. Let's see if there's anything else I want to present to you guys. Okay, the rest of the order, she goes through why she's not granting Richman's request for the government to be restrained, be prevented from using the materials again against Comey. And she goes through the balancing of how she's balancing the interest of both parties, Richman and DOJ. And so Richman gets his property back, but the government gets to keep a copy of it because originally it was lawfully seized pursuant to those search warrants. However, the government must get a new search warrant for those materials if they want to look into them for a case against Comey or against anybody else or in any other investigation. They have to go about it but the proper way. And so that's the balancing that she's going to do here. And then she's going to have those materials filed with a third party, the U.S. District Court for Eastern District of Virginia. And that's where she's striking a balance between it all. It makes sense to me. I'm not sure exactly how many times something like this has been done, but it makes sense to me. And what can happen then is if the government gets a search warrant for them, gets information from those materials for a future prosecution of Comey, whether they refile the case or however they go about it, Comey can then file a motion to suppress, and they can have a new argument about that evidence and where it comes from and whether or not the government should be able to use it against Comey. All that stuff can play out the way it normally would in a criminal case, where you can suppress the evidence against you, or you can argue that it should be suppressed, meaning removed. It shouldn't be available to them. So that's the rest of that order. Now, since that happened, let's go right here. There's been a motion to clarify, and then a sealed memorandum opinion filed, and then extension for the timeline and the motion to clarify, which I already presented in the last video. I went through some of those, but they've continued. And I'm going to check real quick and see the last one I went over in the last video. Okay, so in the previous video, I went all the way up to this one, docket entry number 30. So the next 10 filings are them going back and forth about clarifying things, and the government saying, oh, but we're not sure whether or not you meant that AG Bondi actually had to show up to court. Like, it was kind of silly, to be honest. And the judge slapped him around a bit. Like, she was not happy with the way the United States DOJ was going about this. And then this happened, December 18th and 17th. DOJ files this supplement to their emergency motion. It says the court ordered the government to file a supplement to its previous emergency motion to recommend best practices for the safekeeping of the materials that it's been ordered to deposit in the EDVA. And they're like, we got some of this stuff is classified. There's at least one classified document amongst the material that we're going to be filing. And we need there to be a chain of custody because we plan on possibly using this stuff at some trial. And that's going to be in question. What is the chain of custody of this evidence? And so DOJ filed these materials with the litigation security group, which is part of the DOJ, whose job it is to deal with those materials. How do I say it? That's what they're for, is to secure evidence or materials that could be used in a civil or criminal proceeding. And that's their recommended practices of how they're going to handle it. But the thing is, they didn't file it with the EDVA, which is what they were ordered to do. And then they filed this one saying, hey, by the way, it's going to take a long time to make a copy of the covered materials that you've ordered us to make a copy of, because there's over 1 million documents and it's all electronic data, and it's going to take a long time for us to copy it over to a different drive. So can we have your permission to go ahead and start on that? Which it seems like permission was implied when she told them to do it, right? So she gives this order here, which is a minute order. So it's just like written on the docket. There's not a document that gives it. And she goes over what she's already ordered and then what the government said back. And she's like, as of this date, the government has not certified its compliance with our order, the same order we just read. Accordingly, the government is still under a court order that prohibits it from accessing Richman's covered materials or sharing, disseminating, or disclosing those materials. As the government admits, the government provided a copy of Richman's materials to the Chief Information Security Officer after the government filed its emergency motion, in which they represented that they would continue to comply with their obligation to not access these materials. 3 days after the government lodged a complete copy of Richman's materials with the Chief Information Security Officer, and this is the person in DC, not EDVA, the government moves the court to order that a complete copy of the cover materials be lodged with the the Department of Justice Litigation Security Group. The government does not explain this position any further, but it appears to be arguing that the copy of Richman's materials that the court initially permitted the government to deposit with the district court in the EDVA should instead be deposited with the DOJ's Litigation Security Group. The court would benefit from more briefing on what exactly it is that you guys are doing here. Accordingly, the court orders Petitioner Richman to file a response and for the government to explain themselves, basically is what she says. So things start getting weird here and maybe a bit convoluted because the government is not complying. Instead, they're doing something else, and then they're kind of doing that thing where you act first and ask for permission later. So the government comes back and they file a second emergency motion for clarification and extension of time to certify compliance with the order. And they say, yeah, we know that on December 12th, you ordered us to do this thing, and we didn't do it. And December 15th, we filed an emergency motion for clarification because we were confused. And we told you we were prepared to deposit a copy of the materials, which appeared to include classified information, with the Chief Information Security Officer in the United States District Court for the Eastern District of Virginia, which confuses me right off because we just looked at a document where they're saying, and we have the court's permission to begin making a copy of the covered materials because it's going to take a long time. We're trying to comply with your order as far as possible, but there's a million pages of there's a million documents here. It's going to take a long time for a computer to process it. And so we need your permission to access it in order to make this copy. It's like, wait a minute. You already said that you had a copy and that you were, quote, prepared to deposit a copy with the relevant materials in the EDVA, but you still haven't done it. Shortly after filing that motion in an effort to comply as far as possible with the court's order, the government delivered an electronic medium containing a complete copy of the covered materials to the Chief Information Security Officer in DC to inform the government that they would maintain that copy on behalf of the CISO in Virginia. The government has since been informed by the Department of Justice Litigation Security Group that there is no single classified information security officer for the EDVA. It is the government's understanding that the Department of Justice Litigation Security Group is generally responsible for the maintenance of classified materials on behalf of the federal courts, and that the Litigation Security Group supports the federal courts regarding that subject in civil and criminal litigation. Consequently, it is not clear to the government that the above described electronic medium could properly have been provided to the clerk for the EDVA, particularly given the extreme time pressure created by the deadlines in this case. And then also, Judge, there was some lack of clarity regarding these materials. The December 12th order, what is not clear about this? Okay, I went over that in the past. Okay. The court stated additionally that the government would be required to certify compliance with the December 12th order with specificity and clarified the modified blah, 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 blah. The court has not yet otherwise explained whether the government must provide to Richman the original evidence obtained in the Arctic Haze investigation, whether the government must provide Richman with covered materials in some other fashion, and what else the government must do to comply with the December 12 order. Notwithstanding the passage of time, changes in personnel, and the limits of institutional memory, the government emphasizes that the materials at issue have at all times remained subject to DOJ standard evidence preservation, record retention, and chain of custody protocols. The government is not aware of any destruction, alteration, or loss of original evidence seized pursuant to valid court-authorized warrants. Any uncertainty reflected in the government's present responses regarding the existence or accessibility of certain filtered or derivative working files does not undermine the integrity, completeness, or continued preservation of the original materials lawfully obtained and retained. The government's responses are offered to assist the court in tailoring any appropriate relief under 41G in a manner consistent with its equitable purpose, while preserving the government's lawful interest and constitutional responsibilities with respect to evidence obtained pursuant to valid search warrants and subject to independent preservation obligations. Wow, guys. Wow. Rather than require the government to return or otherwise divest its systems of the information, the government respectfully suggests that the more appropriate remedy would simply be to direct. A doggy came over here. Would simply be to direct the government to continue not to access the information in its possession without obtaining a new search warrant. So they're saying, look, you're having us move this stuff around, make copies, file it under seal in the EDVA. How about you just order us to not access it without a search warrant? This is why I made the comment at the beginning of this video that it seems like they're playing games. Playing some games with this. They're up to something. I'm not ascribing anything nefarious. I'm just saying they're up to something. It is not clear what Fourth Amendment interest would be preserved by ordering the return of copies of information that is already in the movement's possession, and that the government continues to possess, at least in the custody of a court or the DOJ's litigation security group, as may be appropriate given the presence of classified information. And the court's order properly recognizes that it is appropriate for the government to retain the ability. Here's the dog. What are they doing? There you are. And the court's order properly recognizes that it is appropriate for the government to retain the ability to access the materials in the future. Forcing transfer of evidentiary custody from the executive branch to the judiciary would depart from the traditional operation of 41G. The government respectfully suggests that the best way to do that is to allow the executive branch of government to maintain the information in its possession, rather than forcing transfer of evidence to. Man, this is like, okay, this reminds me of when you when you instruct your child to go do a thing, like clean up their room, and I want you to do this with your clothes, and I want you to do this with your toys, and I want you to take stuff off the floor and put it up on a shelf, like all these things, right? You instruct your child on the specific things you want them to do. And then they come back to you and you tell them they have until like 3 p.m. to do it. And then they come to you at 4 p.m. and you're like, did you do the things that I told you to do? And they're like, yeah. Like, okay, so you did this with your clothes. I'm like, well, I put them in the laundry basket. And okay, did you fold your clean clothes? Well, I took my clean clothes out and I put them on my bed. And all right, did you pick up your toys off the floor? Well, I put them over against the wall in one area because I thought blah, 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 blah. Like, okay, did you do this? Did you clean your ceiling fan, or did you dust or clean your windows? Well, we were low on paper towels and I didn't want to use the last paper towels to clean the windows. And my allergies are bothering me, so I didn't want to dust today. Like, there's like this little, like I went a little ways and I went a little ways here and I have an explanation for this and an explanation for that. It just seems like, it reminds me of that. where it's like a almost. It's like in every area with this, there's like, did you comply with the judge's order? It's like, well, we almost did. Also, we have a suggestion as to how the order should be modified, because that would and modified in a way in which we don't have to do anything. And here's, they're playing games. Okay, and then they also want more time. They also want more time. Signed by Todd Blanche, but then also signed by Lindsay Halligan, still listed as the United States Attorney for the Eastern District of Virginia, even though she is not. Okay. So the judge had something to say about that. Okay, so Judge Colleen Kelly Cataller, what is it? Collar Catelli has an order on December 19th. I think that's the same day as this motion, right? Yeah. Well, we're getting all this stuff on December 19th. Who knows when it's actually being entered, because court listener is, and Pacer is now well behind the activities of these courts thanks to the hack over the summer. She says in her order, yo, we got your motion for leave to copy this stuff, and your emergency motion to clarify, and your motion for an extension of time. The court shall resolve the government's motion at a later date as part of a broader order regarding the resolution of this case. In light of the concerns expressed in the government's motions, however, the court shall extend the government's deadline to certify compliance with the court's order of December 12th. Accordingly, it is ordered that the government's deadline to certify compliance with the December 12th order is continued to December 29th. So next Monday. No later than that time, the Attorney General or her designee shall certify with specificity that the government has complied with that court's order, or with that order of docket entry 20, which is the one that we went over at the beginning of this video, and that we went over in the last video. It is further ordered that the government and its agents shall not access Petitioner Richman's covered materials or share, disseminate, disclose, or transfer those materials as it did when it transferred a complete copy of Richman's materials to a CISO in DC without leave of the court to any person without first seeking and obtaining. And she is not happy, guys. She is not happy. At present, in this second request, the court would benefit from an additional detail from Petitioner Richman regarding the government's imaging of his personal computer hard drive. In 2017, Richman consented to the government to seize his personal computer hard drive and make a copy. Footnote. Redacted. What is this spicy? What is this spicy morsel here? The court is requesting information as to whether the hard drive that Petitioner Richman consented to have imaged by the government was ever returned to him, and if so, whether any of the specified material had been removed from the hard drive that was returned. Accordingly, it is ordered that Richman shall inform the court whether the government returned his personal computer hard drive to him, and after it imaged the hard drive pursuant to his consent in 2017, and if the government did return his personal computer hard drive to him after it made the image. When they did so, whether any of the specified material had been removed from the hard drive. It is further ordered that Richman shall include this information in his response to the government's motion by Monday, December 22nd. So, what happened next? Well, quite a bit. And we're going to get to that in the next video. Hope you're enjoying following this case. It's getting more and more interesting. I'll see you in the next one. All right, folks, I'm back with another video covering Richman v. United States. This is going to be the 5th video I've done on this case, I believe. There is a playlist on YouTube and on my Rumble page. And I'm finding it fascinating. I don't know how many of my audience are finding it fascinating, but I'm finding it fascinating. And I think this case is going to be, I'm kind of perplexed that it's not getting more coverage in media, because it's highly, highly consequential to whatever happens with whatever case is brought against Comey or is not brought against Comey. And I also think it could be highly consequential to some other cases that we would like to see brought, such as a case against McCabe or whoever it was who was actually leaking classified material to the New York Times and Wall Street Journal and other outlets. And it's dealing with evidence that could be relevant to a number of those investigations. Um, so I'm kind of perplexed when I search around in media to see what others are saying about it. I find nothing. It's like the initial action happened here. Richman filed to get his stuff back. A temporary restraining order was put in place. People on the right freaked out. Media and influence on the right freaked out and did their rage baiting content about how crooked DC judge is protecting James Comey. And then nothing. Everybody just forgot about it. And maybe they forgot about it because it doesn't fit the narrative that they were trying to put forth. Or maybe, it's just there's so much else happening in the world. They just, steered towards that. But I haven't forgotten about it. And if you're here watching this video, considering that it's the fourth video I've made, I'm pretty sure maybe it's video 5. I should probably check. If you're here watching it, this is going to be episode 5. Yeah, it's going to be the 5th video I've made covering it. If you're here watching it, that means you haven't forgotten about it either. So thank you very much for being here. Make sure you're following me. Go to my link tree. You can find other places to follow, watch, listen, and support. If you would like to keep me caffeinated, Ko-Fi.com is a great way to do that. If you would like to support my pacer addiction and coffee habit, justhuman.substack.com. Paid subscription there, $7 a month. You contribute to the Pacer Fund, and you contribute to my coffee fund. So thank you very much. So in the last video, we covered up through filings on December 19th. Today, we're going to cover December 22nd through the end. And it looks like several filings, but they're actually not very many pages. I think 1, maybe 2 of them are 14 pages, but the rest are very short. But that doesn't mean they're not interesting. We're going to learn some things. We're going to learn a couple things. Will the DOJ fully comply with Judge Colleen Collar-Cotelli's order of 2 weeks ago telling them to file a copy of the Richman material under seal in the EDVA? I doubt it. Will we learn why they've done what they've done? Maybe a little bit. Will we learn that the government has made more copies of Richman's material than they originally informed the court existed? Let's find out. So first thing we see here is there's a sealed motion by Richman because he wants to file a document. It's an attachment right here and then an exhibit. And it is sealed and it was filed. And I think it's an answer to the judge's question about whether or not he knows if the government gave him back his original hard drive way back in 2017. And there might be some more to it. I'm wondering if the exhibit could be, or it could be it's in the attachment too, the first one. But I'm wondering if this also contains a copy of the agreement that was filled out with the government when he volunteered that hard drive to them so that they could delete the Comey memo off of it. Remember, that was the whole thing where that started. Was that the government originally came in possession of some of Richman's digital material because they had learned about the existence of Comey memos and those memos being sent to Comey's lawyers. And they had upclassified a few of those memos. The memos were just they weren't classified at all. And they were upclassified, and so the government scrambled to go and find them, and that the people scrambling to do it were James Baker and Peter Strzok, if I remember correctly. And they went and got Richman's hard drive. He volunteered it to them for certain purpose of removing the classified information that they said was on it. And then they gave it back to him after they removed that. But it looks like they may have done more than that with it. And Richman said he can't certify that they gave him back the original. All right, so that was filed under seal here. The next thing we get is a response to the court order from Richmond, and it includes a declaration from someone named Nicholas J. Lewin. So let's see what this is about. This is one of the longer ones. This is actually the longest document we're going to read. It's 14 pages, but some of it we may just skip over because it's just so repetitive. All right, response of petitioner Daniel Richman to the court's December 18th and December 19th orders. She was asking for more information from Richmond and from the DOJ. All right, Richmond submits the following response to the court's order. In those orders, the court directed Richmond to 1, address the government's argument that the court should permit the government to deposit a copy of Richmond's materials with DOJ's litigation security group instead of the District Court of Eastern Virginia, which is what the judge had originally ordered. Remember, DOJ did not quite what the judge asked, but did a thing, and then now is asking permission to let that be sufficient. 2, whether the hard drive that petitioner Richmond consented to have imaged by the government was returned to Richmond, and if so, whether any of the specific material had been removed from the hard drive that was returned. For reasons set forth below, Richmond objects to the government's request to deposit his materials with the DOJ's LSG. Okay, that's the litigation security group, instead of the EDVA. With respect to the hard drive, Professor Richmond can confirm that a hard drive was returned to him, but he does not know whether it was the same hard drive he provided to the government. Based on the government's 2019 and 2020 warrant applications, though, it appears that it was not. Holy... What? What? So many questions about that and what that might mean. One thought I had when I first glanced at this was, did Cache's directors group find Richmond's original hard drive in that SCIF? And that's what this whole thing is really about? Is that something weird went on with that? Something potentially criminal? Dude. This could open up a very scandalous can of worms. Maybe it doesn't, but this is a bombshell in this case. All right, Professor Richmond strongly objects to the government's post hoc request. That's the fancy way to say they did it and asked permission for it later. That's what your kids do, right? That's the example I was giving on the last video. It's like when you instruct your kids to go do a thing, like some chore, and they kind of do it, but not really, and definitely not as you described for them to do. And then they come back to you and say, yeah, I did it. But the thing is, I did it this way. And it's like, no, so you didn't do what I told you to do at all. Like, right, but is that okay? That's okay, right? Because I kind of sort of did. To deposit, okay, so their post hoc request to deposit the cover materials with the LSG rather than the EDVA court. By means of brief background, December 12th, the court ordered or granted Professor Richmond's motion to return the materials under Rule 41G. The government was to return to Richmond all copies of the cover material with the exception of one complete copy of the materials, which the court authorized the government to prepare and deposit under seal for future access pursuant to a lawful search warrant and judicial order. As the court correctly explained in its accompanying memorandum opinion, in light of the government's previous failure to maintain Professor Richmond's files, in a manner that adequately protects his right to be free from unreasonable search and seizures, allowing the government to retain a copy in its own possession would not provide adequate redress to Petitioner Richman. Since December 12, the government has filed a litany of motions and other papers with meritless, half-formed, and insufficiently predicated arguments that, even if not specifically calculated to create unnecessary confusion and delay, have certainly had that effect. What a line. Okay, I need to kind of like pause and take that sentence in because I like it. Since December 12, the government has filed a litany of motions and other papers with meritless, half-formed, and insufficiently predicated arguments that, even if not specifically calculated to create unnecessary confusion and delay, have certainly had that effect. I want to direct that. I want to save this and just like control V it. I just want to like paste this in response to basically everything Jack Posobiec, Tucker Carlson, Candace Owens, and all of these conspiracy brain rot, woke right, malactors, and shitheads that are infiltrating the MAGA movement and trying to take control of it. Like, this is such a beautiful way to respond to someone's nonsense. Man, I like it. Man, I like it so much. Okay. I don't know why it hits. It's just, I don't know. I like it a lot. All right. It has a footnote, a rather large one. Let's check it out. You often find some really interesting things in footnotes. Although presented as a request for clarification, the seriatim, that is the word of the day, folks. Let's look at this word. This is going to tell us to pronounce it seriatim. Seriatim, one after another and in order, taking one topic or subject at a time in order sequentially. Seriatim, that is your word of the day. I challenge you to find an occasion in which to use this word. Ooh, let's listen to it. Seriatim. The voice. Oh, you guys can't hear it. All right, prepare. This sounds like a voice from a almost a Twilight Zone, like classic Twilight Zone voice.
Seriatim. Seriatim.
Seriatim.
Seriatim.
All right. Thanks for having fun with me for a minute. Okay. Although presented as a request for clarification, the seriatim, repetitive filings, essentially seek the same thing: that the court reconsider its decision. For example, on December 18th, the government sought permission to create a new copy of the cover materials for the purpose of sharing it with Richman, but the court has not ordered the government to give Professor Richman a copy of materials. It has ordered the government to return all copies of the covered materials and certified that it has not made or retained any additional copies. Similarly, in its December 19th submission, the government claimed confusion about the court's statement that it has not ordered the government to delete or destroy evidence, given the court's instruction that the government not retain copies of covered materials. But there is no conflict. The government has materials that it obtained from Professor Richman. These, at the risk of saying the obvious, are evidence. It then appears to have made myriad copies of pieces of that evidence, authorized and otherwise. Does it continue? Yes, it does. These are copies. The court's order is simple: provide a full set of the original evidence to Professor Richman, provide a full set of the original evidence to the EDVA District Court, if the government wishes to do so, and either return any additional copies to Professor Richman or delete them, such that nothing remains in the government's possession. That's the whole point of the December 12 order, right? In any event, for the reasons set forth in the December 12 memorandum opinion, Professor Richman's previous briefing and this filing, the court assuredly should not consider its decision based on these or any of the government's submissions. Indeed, the government's recent submissions and the facts included in them powerfully reinforce the need for the court to stand by its decision and ensure that the government swiftly comply with it. So here's what I was talking about with them making copies. DOJ did not tell the court, oh, we have X number of copies of these things. Are we to give him all of those? Should we give him one? What should we do with these? And then they had I don't know, kind of the gall to go to the court for permission in a filing I covered last video, asking for permission to start making a new copy because it's going to take so long to. There it is. It's going to take so long to do it because it's digital and there's like a million documents. Here it is. Motion for leave to copy the covered materials. But yet we learn in another filing, as was mentioned just there in the footnote, that there already are other copies. So, all right. In a filing submitted on December 18th, which was, and I agree with this. This is kind of the ad hoc. I agree that what's going on is that the DOJ, instead of appealing or like filing for reconsideration or anything like that, they're doing these other actions that have the effect of pushing the court to reconsider its December 12th order. Because they're saying, well, would you let us do this? Well, would you let us do this? What about if we did this? Okay, look, we did this, judge. Is that good enough? Right, that's the game they're playing. All right, December 18th, which was supposed to recommend best practices on safekeeping evidence that was to be deposited in the EDVA District Court, the government disclosed that it had lodged a complete copy of the covered materials, including classified information, with a CISO, a classified information security officer in Washington, D.C. It is not clear whether this, quote, complete copy is the same set the government originally prepared for the purpose of lodging it with the EDVA District Court, but which it provided instead to another office of DOJ, without the court's authorization, mind you, or another new set which would have been created without the court's authorization. But at a minimum, as the court has already recognized, in either event it constitutes sharing, disseminating, and disclosing the covered materials in violation of the December 6th temporary restraining order. In its December 18th and 19th submissions, the government requested that the copy of the covered materials it lodged with LSG without the court's permission be allowed to remain there, rather than with the EDVA District Court, and the court should promptly deny this request. The government's purported concerns about chain of custody and the EDVA District Court's ability to safeguard classified information are a smokescreen. You know what? I see that used. You probably do too. You see it alleged that, oh, they're just creating a smokescreen with this, with whatever, this excuse or thing. I think that this is like one of the most apt occasions for that to be said about something. They're definitely creating a smokescreen. I think it's a good use of that description. I see it misused all the time. But here I think it is very appropriate. Federal courts regularly store classified material. I mean, duh. Indeed, the EDVA District Court in particular has handled many of the most sensitive national security matters in recent history of the U.S. As the government well knows, or at least should know, such cases regularly require judges, their clerks, and their staff to receive, review, generate, and store classified information. The government ignores that manifest fact and claims that the only way for such information to be stored is with one of its own employees, a classified information security officer who works for one of its own departments, the LSG. That is simply false. The EDVA District Court plainly can store classified information, and certainly a single memorandum classified at confidential level. So they're talking about the Comey Memo. They're talking about the Comey Memo. One of them. To the extent the government claims otherwise, it should be directed to put in an affidavit setting forth its position that the EDVA District Court is not equipped to store classified information. Let's look right here. Are any of these worth checking out? Yeah, the classified information is a single memorandum that was unclassified when it was shared with Richmond, but was later upclassified to the lowest classification level of confidential. It's the memo about as we covered in a different video. It's the memo that Comey wrote down after meeting with Trump, where he wrote that Trump told him he hoped he could see his way to letting Flynn go, which has been interpreted to mean Trump was asking Comey to stop investigating Michael Flynn and to just let that investigation die, and that there was something unethical about that, which is kind of weird, to be honest, because, sorry if I'm going on another tangent, but I'm going to go ahead and do it. I just saw a post with Trump directing the AG, and by extension, the FBI director, to investigate a certain person. So Trump directing Bondi and Kash Patel, you should go and investigate this one person. And somehow, mostly people on the right are like, yay, good job, that's awesome, do it, that's what I voted for. But then with Trump meeting with Comey, the right is all, boo, that's terrible. That must be a lie. The president would never do that. The president would never ask Comey to stop investigating someone. Yet we know he would ask the FBI director and AG to start investigating someone. But with the Comey thing and Flynn, the left is, boo, that's terrible that the president is telling the FBI director to stop an investigation. But you guys know that if it had been the other way around, if Trump had told Comey to investigate someone, the left would say it was bad. But him telling him to stop investigating someone, the left also says it's bad. Meanwhile, the right says, yay, I voted for him to tell them to stop investigating them or to start. Like, it's just so silly. It's just so silly. You know what is like totally reasonable? You know what's like totally the most rational place to be, probably, or at least in my opinion? It's okay for the president to tell the AG or the FBI director, I think you should investigate this person, or I think you should stop investigating that person. Like, I think it's fine either way. I think it's totally fine. Whoop-de-doo. He's the chief executive officer of the country. And all executive power flows from the president. And he's free to give his thoughts. And if he says to the FBI director, man, I hope you can see your way towards to letting Flynn go. What's the big deal? Just like him saying, I hope you could see your way towards investigating this other person over there. I think they're up to some bad stuff. I hope you can see your way to letting Flynn go. He's actually a really good guy, and he didn't do anything wrong on the phone call. You see how they create political scandals depending on how they frame it? And by they, I mean people on both sides and media and political operators. Creating scandals where there isn't one. Okay. It mentioned some interesting cases. Curacao, he's a well, I don't have anything nice to say about Curacao other than he's a really good storyteller. I'll say that about him. Hansen is the FBI version of Curacao in some ways. Both work for the Russians, or did. United States v. Ames. I don't recall that one, but it's espionage prosecution of a senior CIA officer. It should ring it. It's from 94. I don't remember it. Moussaoui. I know that one. 2001. Okay. It's just giving some examples of cases in the EDVA that had really highly sensitive information. For at least 2 decades and very likely far longer than that, there has been a sensitive compartment and facility in the EDVA courthouse. Material classified at the lowest classification level, which is confidential, can be stored outside a SCIF as long as it's in a GSA approved safe or cabinet. Okay, so that's what those footnotes were. There's another footnote here. Let's see what this one says. So it starts. I got to reread the sentence. To the extent the government claims otherwise, it should be directed to put in an affidavit setting forth its position that the EDVA District Court is not equipped to store classified information, which of course it is. Footnote: if it cannot do that, the court should inquire as to the basis for the government's prior representations, including this one. Quote: it is not clear to the government that the materials could properly have been provided to the clerk for the EDVA. So that's coming from a filing the government made where they tried to explain why they had given this Richman material, including the classified memo, to the LSG, and why they could not give it to someone in the EDVA. And it just didn't pass the smell test. To address its purported concerns about safeguarding chain of custody, the government need merely place a copy of the materials in a sealed evidence bag and have an agent deliver the bag to the courthouse for storage in a SCIF or other locked access controlled space. In the event the government later obtains judicial authorization to access the covered materials, an agent can pick up the sealed evidence bag and confirm that it remains sealed. This is more than sufficient to demonstrate that, as a matter of reasonable probability, possibilities of misidentification and adulteration have been eliminated. Plainly, there is neither a legitimate chain of custody problem nor a problem with judicial storage of classified material. But LSG, which is the DOJ, keeping a copy of the materials would be a problem, and a big one. For reasons set forth in the December 12th memorandum and opinion, the fox must not be permitted to guard the henhouse. And that is, I see that expression misused, and it's appropriate here. Remember what they did. The DOJ, just 6 months ago, violated Mr. Richman's constitutional rights when they searched through these materials without a search warrant. That's the whole reason for like half of what is in the December 12th order. DOJ has already demonstrated that they mishandled this material. Given the history of this case, including both the underlying facts that led this court to find callous disregard towards Richman's constitutional rights and the very recent violation of this court's orders against sharing, disseminating, or disclosing covered materials, the government's contention that it is not clear what Fourth Amendment interest would be served by ordering the return of copies of information that the government continues to possess strains credulity. Frankly, with all due respect, at this point and in light of the foregoing, it would be naive to simply presume government compliance. Per the court's order, the government is permitted to lodge a copy of the covered materials with the EDVA District Court, but the government's own prior actions dictate that it should not be permitted to serve as the material's custodian. They've already failed at that job in a number of ways. As the court has already found, the EDVA District Court is well situated to ensure that any future access by the government to covered materials is lawful, including by affording Richmond an opportunity to be heard in connection with any future warrant applications. In making this finding, the court has endeavored to ensure that in any such future effort, the government complies with the Constitution and does not gain any improper advantage from its prior violations of it. The court should adhere to its previous ruling, for all the reasons set forth in the December 12 memorandum and opinion, and should deny the government's request to allow LSG to maintain a copy of the materials in lieu of the EDVA District Court. Shifting possession of Richmond's materials from one DOJ office to another is inconsistent with the law and the fundamental principles animating this court's orders. The court was fully within its equitable powers to craft the relief that it did, particularly given the government's past conduct, and as powerfully demonstrated by its recent conduct. Consistent with the court's December 12 order, the government should retain no copies of the covered materials. Okay, now here we get to the hard drive issue. The government returned a hard drive to Professor Richman in 2017 inside his Apple iMac computer, but he does not know whether it was the same one he provided to the government. However, it appears from the record that the government may have improperly kept the original hard drive and installed a replacement in the computer. It also appears from the record that the government may have made at least 4 forensic copies of the drive. Oh boy. Oh boy. The fact that the Department of Justice may presently hold 5 copies of the data from Professor Richman's computer, in addition to his iCloud backups and his Columbia University email communications, powerfully highlights the breadth of the government's violation of not only Professor Richman's constitutional rights, but his basic expectation of privacy. It warrants a brief review of the breadth and the unlawfully seized, retained, and searched materials as set forth in the prior briefing. And here's a quote from that prior briefing. The seized materials constituted effectively the entirety of Professor Richman's digital life. Personal, professional communications, backup files, forensic, and the hard drive contained a forensic image of Professor Richman's personal computer, as well as backup files for Professor Richman's iPad and iPhone, iCloud account, data, photographs, applications, etc., etc., etc. It also had the Columbia email accounts, had correspondence for professional and personal use with applicants and students and law clerks and judges, etc., etc., etc. After Professor Richman signed the June 13th, 2017 consent, I would love to see that form, the government took temporary possession of his computer, which contained an internal hard drive. As noted in the consent, Professor Richman agreed to allow the government to create a forensic image of the drive and delete 4 documents. They were memoranda written by James Comey with the government, which the government believed were potentially classified. Footnote: none of these memoranda were classified at the time Richman received them. One was upclassified to confidential later on, after this whole thing took place. The government subsequently returned the computer to Professor Richman with an internal hard drive that did not include the 4 documents in question. Professor Richman never opened the computer physically to inspect the hard drive after it was returned by the government and no longer possesses it. And then that's where this declaration comes in, which we are going to go ahead and jump over and look at. This declaration is only 2 pages. This is Nicholas J. Lewin, who is counsel to Professor Richman. Okay. Nicholas J. Lewin, partner at KKL LLP, counsel to Richman, says, as such, I'm familiar with the facts and circumstances set forth herein. Here's my declaration. I presently maintain a top secret compartmented information security clearance and have access to the sensitive compartmented information facility, the SCIF, located at the Daniel Patrick Moynihan Courthouse in New York, New York. The government returned Richman's Apple iMac computer to him in 2017, defined as computer in the accompanying brief. Petitioner Richman no longer possesses the computer, and he never examined the serial number of the hard drive inside the computer after it was returned to him by the government. As a result, he is unaware today whether the government returned his original hard drive to him or whether the government returned his computer after replacing the original hard drive with a new hard drive. I declare under penalty of perjury that this is true and correct. Okay. Sounds more like we don't know for sure. We can't confirm. So what is their reason to believe that they fecked it? They kept it. Sorry, they fecked it. They kept it. However, if the government in fact kept the original hard drive and gave Richman a replacement, as discussed in the next part, that would have violated the consent, as Professor Richman did not consent to the government keeping any of his devices. Rather than helping to clarify the government's actions, the subsequent search warrants aimed at Richman's hard drive, see attached sealed exhibits A and D, which are the hard drive warrants. Man, I would like to see those. Hopefully we will at some point in this case. Indeed, a close review of the hard drive warrants suggests the possibility of both. 1. a violation of terms of Professor Richman's initial consent, and 2, yet another FBI action that was contrary to the judicial authorization in at least the hard drive warrant. Number 1. Back in 2017, Richman's computer contained an internal hard drive with a serial number ending in redacted. In June 2017, as explained above, Richman voluntarily gave consent to the FBI to create a forensic image of the redacted hard drive and to delete the documents in question. I'm assuming what's under that redacted block either has some numbers or something that's short for this. And he physically handed over the computer to the FBI. Then it says redacted. And that's a sentence. Professor Richman did not give the FBI consent to physically seize the hard drive. Rather, the FBI was authorized to make a forensic image of that hard drive, to delete 4 specific documents from it, and then return the computer, including that hard drive, to him. As the court knows, about 2 years later, in August 2019, the FBI obtained a warrant to search a forensic image of Richman's hard drive. This hard drive, which sought permission to redacted, and then the footnote redacted, and then more redactions, except for they give us the word if. It appears, then, that the FBI unlawfully seized and retained the original hard drive in violation of the consent. They would, of course, also suggest that the FBI still retains unlawful possession of that hard drive, in addition to the other hard drive. It appears that the FBI also made and maintained multiple forensic images of the hard drive, more redactions. It does not appear, footnote, it does not appear that the agent disclosed to the judge in the hard drive warrant number 1 application that redacted. When the FBI processed a copy of that redacted hard drive in May 2020, it may have violated the court order, more redactions. In light of the foregoing, it appears that 1, the FBI improperly retained the original hard drive from Professor Richman's computer in 2017. The FBI created at least 3 additional copies of that drive, a forensic copy, the redacted hard drive, and the redacted hard drive. And 3, the government may have unlawfully accessed one of those hard drives in May 2020 to create another hard drive. In addition, it is a fair inference from the facts that the FBI created at least a 4th forensic copy of the hard drive, which it provided to the DOJ's Office of Inspector General in response to the September 2017 consent signed by Richman. Another forensic copy which may be in the possession of DOJ. To the extent the government retained the original hard drive, as strongly suggested, redacted, that original hard drive should be treated as covered materials, along with all other forensic copies of the same, for purposes of the court's orders requiring the return to the covered materials and prohibiting the government from accessing, sharing, disseminating, disclosing, or transferring those materials. For avoidance of doubt, footnote, if this or any storage device in the government's possession includes the classified memorandum, Richman continues to consent to the deletion of that document. Dude, Richman respectfully suggests that the next steps here are clear and are clearly warranted. Step 1, deliver a full copy set to the EDVA. He's asking the judge to propose an order that says, 1, DOJ should deliver a full copy of these set of hard drives to the EDVA. The government should be directed to deliver a full copy set of covered materials that is currently in possession of the LSG to the EDVA. To the extent the government believes it is necessary, it should be permitted to have a chain of custody FBI agent accompany the DOJ CISO for this delivery. And to the extent these materials contain the purported classified information, those materials may be stored in a SCIF or GSA-approved security container located in the Alexandria Federal Courthouse. Step 2, return all electronic storage devices containing original or forensic copies. Yeah, to Richman, right? By a certain date, the government should be directed to identify all electronic storage devices constituting or containing Richman's original seized materials or forensic copies of those materials and return them to him through counsel. They can delete the classified memorandum if it exists on any of them. Alternatively, with respect to the classified document, the court could also consider directing the government to either one, permanently delete and destroy any electronic storage device on which that memorandum is or was saved, and certify the same in a court order, or to certify the same to the court, or two, via the DOJ CISO, return any electronic storage devices containing that memorandum to undersigned counsel who has a security clearance. And he can store it in the SCIF in Manhattan. Step 3, deletion and destruction of copies. By a certain date, the government should be directed to delete from all DOJ and FBI investigative systems and any other electronic devices all copies of the covered materials, as well as printed copies of the same, which we know there are printed copies because they came up in US v. Comey. Step 4, certify by a certain date that this has all been done, that no copies remain in the DOJ or FBI's possession. Until these 4 steps are complete, the court's December 19th, 2025 order should be continued. Finally, in light of the events of the last 3 weeks, Richman respectfully requests that the court consider directing the government identify and use an independent wall team with no prior connection to the Harta case investigation or Comey cases to carry out the court's directives. Ideally, the wall team would be comprised of and supervised by career DOJ prosecutors who are not drawn from either the U.S. Attorney's Office for D.C., which is the office that handled the Harta case investigation, or the U.S. Attorney's Office for the EDVA. Interesting. That's a very interesting request. And it's, given the government's behavior here, it makes a lot of sense. Okay, so things just got a bit more scandalous with this case. And if you missed it, what we can infer from these redactions here in the way that they summed it up here, these multiple copies, is that Richman in 2017, in May and June 2017, when he got his hard drive back, or he got his computer back, he assumed the original hard drive was still in it. And now that they've gone back and looked, they realize in the documentation for the Arctic Haze investigation, which also seized that same computer, that's where it's come up that, the serial number on that hard drive isn't the same as it was in May and June of 2017 when we originally created a copy. So these 2 different investigations, both one about the Comey memos, the other about leaks to the New York Times, both seized the same computer from Richmond, and they both recorded a different serial number on the hard drive there. That's how they figured out that something's gone on with the original hard drive, and Richmond never got it back. And then since then, they've created more copies. And I don't know what's under all of these redaction blocks, of course. I don't know if it has a date or if it has a code name. They're very short. So it might just be like a couple, like the end letters or numbers or something on the hard drive. I'm not sure. But either way, it adds up to there being at least 4 copies of this hard drive floating around, plus whatever's been printed or copied, and sections of it have been copied. So there are still a lot of redactions here. And I'm guessing it all has to do with Arctic Haze. Okay. Next thing that happens. Let's see, we are here. The court then issued an order. This is short minute order, so there's no document with it. It's just on here on file, or on the docket, I should say. Granting his motion to seal this stuff here. See if it has a direction. Okay, but she hasn't granted the order there. The next day, she does issue an order with a memorandum. And here's her order. And It is also, the memorandum is also 14 pages. So her order is, she grants the government's emergency motion in part and denies in part. That is 33, docket entry 33. So that one was for motion to clarify and extension of time for the government to comply with the court's order. She gives them, let's see. She tells them again, you're ordered to file a complete copy with the Eastern District of Virginia. And then the copy you gave to the litigation security group, yeah, give that to the EDVA. And this is all to be done before December 29th. Further order that the government shall file or shall be permitted to have a chain of custody agent accompany these things. Finally, it's ordered that the custodian of these materials shall not share, disseminate, or disclose them to anyone except for when pursuant to an appropriate search warrant. And then you have until December 29th to return all these things to Professor Richman. And the court orders the government to certify compliance that it has done both of these things by December 29th. And she denies the government's motion for permission to make another copy of the materials. Okay. Here's some memorandum. We're going to go through it. I think there's going to be a section of it we can skip, but we're going to go through the whole thing. Okay. Yep. I'm going to cover this on the next video. I'm going to go ahead and release this one as is, and then this will be this one, and then they asked for more time on Christmas Eve. They asked for another order for more time. All right. Yep. All right. I'll see you guys in the next video. All right. Here's your what's going on right now in Richmond v. United States. Latest update on that case. There was an order on December 23rd, which is basically the same thing as the order on December 12th, when the judge first ordered the government to, hey, separate all this stuff, give a copy of it to Richmond, or the original stuff to Richmond, and then file a copy under seal in the EDVA. And if you need it for some reason, get a search warrant. It's really simple. She keeps on having to repeat these instructions, and the government keeps on not complying with them. And on December 23rd, she filed her memorandum and opinion, just reiterating all of it and saying, look, the government's now filed 2 emergency motions requesting clarification and modification of the court's order. And the government suggested it may be required to delete or destroy evidence it lawfully obtained, but the court's order does not order it to do such a thing. The court ordered the government to return certain materials to Richmond and then make a copy of the rest and file it under seal in the EDVA. They can get a search warrant for it if they need access to them. Moreover, the record establishes that the government is not entitled to retain any of the materials originally seized from Richmond or copies thereof. The record strongly suggests that when executing the 4 search warrants on Richmond in 2019 and 2020, the government failed to separate and segregate materials that was responsive to those warrants from material that was not responsive. The government candidly admits that it cannot currently point to a segregated collection. That's their admission. The government has therefore failed to establish any reason why the court should order that a copy of Richmond's covered materials be lodged with the DOJ's litigation security group, rather than U.S. District Court of EDVA. Because the government has not kept a segregated set of responsive materials, its warrantless search of Richmond's materials in 2025 was conducted on an unscoped image of his devices. This warrantless search was plainly unreasonable under the Fourth Amendment. Furthermore, because the government has not retained a segregated set of materials that are responsive to those warrants, it cannot now rely on those warrants for authority to retain any of the seized materials it seized when executing them, or any copies thereof, which we recently learned there's like 5 copies of them. And they're not segregated either. The government has also failed to show that the court's order unduly burdens the government's obligations to safeguard classified or privileged information that it failed to show the court order conflicts with. Accordingly, the court will require the government to return the same thing we've been requiring of you since December 12th. That's what she writes in here. Then, what do you think they do? What do you think DOJ does? You guessed it, another emergency motion. United States moves pursuant to Federal Rules of Criminal Procedure 6B and 59E for an order partially extending the time for the government to certify compliance with the court's order of December 12th. In support of this motion to partially extend the compliance, the government writes the attached memorandum. And in that memorandum, they say, look, yeah, you told us to do all these things back on December 12th. And on December 23rd, you issued an order clarifying your December 12th order. And you ordered that the custodian of these materials not share or disseminate them. And you ordered that on or before December 29th, the government is to return to Richmond through counsel all the electronic storage devices constituting and containing the original seized materials or forensic copies of those materials. You further ordered that to the extent the purportedly classified memo from Comey, which was the whole reason they initially went in 2017 to get stuff from Richmond, that was voluntarily, that the government shall be permitted to permanently delete that file from the device, his hard drive, which they never returned to him in the first place. They replaced his hard drive and didn't tell him about it. The court ordered the AG or her designee to certify by December 29th that they complied. Finally, the court ordered that the government not access the covered materials except for the limited purpose of deleting classified memos. Well, Federal Rules of Criminal Procedure provide that when an act may or must be done within a specified time, the court may, for good cause, extend time. And what constitutes good cause necessarily varies from circumstance to circumstance. As the timing of this filing, as of the time of this filing, the government anticipates that it will be able to provide the complete set of covered materials currently in the possession of the Litigation Security Group to the EDVA by December 29th. Finally, that it will be able to provide counsel for Richmond those electronic storage devices not currently containing any classified material by December 29th. Finally, however, because of significant operational constraints caused by Christmas and New Year's, which is lack of sufficient technically qualified government personnel in DC for the remainder of this week and next, which made the current compliance deadline fall a mere 1 business day before the court's compliance deadline fall a mere 1 business day after the court's revised clarifying order. The government anticipates that it will not be able to review all electronic storage devices containing classified information, delete that information, and return those devices to Richmond. The government is also in the process of identifying all department components that may have pertinent electronic storage devices. Guys, how many people in DOJ and for what purpose got copies of the materials seized from Richmond pursuant to the Arctic Haze search warrants? Please remember that originally this was described as one set, one forensic image, like a Blu-ray disc. Now we learn that they're still identifying all the different departments within DOJ which have or may have pertinent electronic storage devices related to these materials. In order to fully comply with the court's order, the government requests an additional week. We need an additional week to look for these things and check to make sure they don't contain classified information, and if they do, delete that information so that we can give them to Richmond. So now the government request, DOJ is requesting that they have until January 5th, 2026. The government will comply with the TRO, except to the extent that it needs to delete classified information from the devices. We've talked to Richmond about it, and he takes no position. Signed, Lindsay Halligan, who still signs as the United States Attorney for the Eastern District of Virginia, even though she's been disqualified. Ann McBride and Todd Blanche. So we get another order, December 27th, another order. And the judge grants in part and denies in parts that motion. She gives them until July 5th. Here, let's see. Let me do this. Let me be fair about this. Given the holidays, the court shall grant the government's request to extend its deadline to certify compliance. However, the government's motion also appears to request permission to search Richmond's materials for classified material without first obtaining a valid search warrant, which would be in direct contravention of the court's prior order. Accordingly, because the court has already ordered that the government may not search Richmond's material to identify additional classified information without first obtaining a valid search warrant, the government's request is denied. To ensure the government understands its obligation under the court's prior orders regarding the deletion of classified information, the court shall take the remainder of this order to re-emphasize those obligations. So, to be clear, DOJ, this is what you got to do. You got to give Richmond back his material, except for one copy of it, which you are to create and file in the EDVA. If you think there's classified information on that material that I'm ordering you to give to Richmond, get a search warrant for it. Get a search warrant for it. Get that granted. Go into the material, find that specific thing, delete it, and then return it to him. They've made this like DOJ has made this as difficult as possible. Like, it's weird. It's something else. Something's up, guys. Something is up. This is not just them being obtuse or stubborn. Something is up. I'm not sure exactly what it is, but something's up. And what do you want to bet? They get a search warrant and they find classified material that was more than what they thought was there. The rest of this just goes on to re-emphasize what she already said. She restates her order for the upteenth time. But she also says, Petitioner Richmond has consented multiple times to having the government delete the classified memo from the material that is returned to him. While the court has clearly ordered the government may delete the single classified memo from Comey from the material it seized from Richmond's personal hard drive in 2017, the court has been equally clear in ordering that the government may not conduct any additional review of Richmond's materials for classified material without first obtaining a valid search warrant. You have until January 5th. Remember, they've already violated her order. They violated her order when they gave the material to the litigation security group instead of the EDVA, which was a violation of her order to not disseminate or disclose or transfer these materials to any person without first obtaining permission from the court. Something's up. Something's up. And right now, not trying to play Nostradamus here or something, but I've been right about this case and about Comey case a few times. I've read the tea leaves a few times. I've read them correctly a few times in the history of this case and in Comey. And what the tea leaves indicate to me is that there's a reason there's so many copies of this material, and there's a reason why it's in different places at DOJ, and there's a reason why the government is being obtuse and stubborn about this and basically delay. And I I I just get the feeling that they're going to get a search warrant, and it's going to be something like while checking to make sure there's no classified material on these other Richmond devices, we found more classified material than we expected to. I wonder if the Arctic Haze investigation is going to be reopened. Put a pin in that. Put a pin in that. Okay. All right. That's it for this update. I will see you. No, I keep on saying at the end of these videos, I'll see you in the next video, which isn't true. I don't see you in the next video. You see me. So until next time, stay human, and you'll see me in the next video. Okay, I'm back with another video covering Richmond v. United States. This is going to be video numbers, episode 7. I don't know if you've noticed, but I started putting episode numbers in the description of them just to help people keep track because there's been so many of them. And another super pro moment where I failed to tell the OBS which page to look at. There has been a couple filings since I last covered this. And I don't think I'm going to be going on. I don't think this video is going to be very long. Of course, famous under appreciation of what's in front of me. There's a filing by Stanley Woodward. He was a longtime Trump and Rudy Giuliani associate. Going back, he's band associate, or band adjacent, in my opinion anyway. Like just kind of playing loose with the whole idea of the band anyway. He's just a regular in Trump and Rudy Giuliani world. And he's filed an appearance here, which he is the associate attorney general or something. We'll see what he signs off as. But since we last spoke, there's only been this one short filing. And let me get his title exactly, because I think he's I was right, associate attorney general. Okay. And he was counsel for Rudy in a case, and then he was also defense attorney for Mark Meadows, I believe, in the Jack Smith case. So he's filed this motion here, which hasn't been ruled on yet, unopposed motion to extend the government's compliance deadline. So it's like, okay, here we are again. DOJ wants more time to comply with the judge's orders. But there's a little more in this. Respondent USA, by and through undersigned counsel, hereby moves this court pursuant to Rule 6B1A of the Federal Rules of Criminal Procedure, further extending or civil procedure, not criminal, for an order further extending the deadline by which the U.S. must certify its compliance with the court's December 12 order, the main order in this case, which is presently January 5th, is the date they have to comply by, which is Monday. In the days since the court last extended the foregoing deadline, the undersigned counsel, meaning Stanley Woodward, has endeavored to negotiate in good faith with the counsel for the petitioner, which would be Daniel Richman, has endeavored to negotiate in good faith with Richman the particulars of the party's understanding of what compliance with the court orders requires. For example, classified information cannot be deleted from the government's forensic copy of electronic media without the destruction of the entire media, which makes sense because it's a forensic copy. That's the purpose of making a forensic copy. That's what makes it forensic, is that it stays exactly as it is and you can reference it as a piece of evidence. Thus, although the court's orders, quote, permit the government to permanently delete a single classified document from the material seized from Richmond's personal computer hard drive, which we know what that is, it's one Comey memo, from any of these materials before returning them to petitioner Richmond, such limited deletion of classified information from a forensic image is not technologically feasible. And there's a footnote here. Where'd it go? I don't see what word it's on here, but it's for some reason my eyes are not picking out where the number 1 is. Regardless, right here it says counsel for petitioner movement has advised the undersigned counsel that although Richmond does not join in the request for the United States to extend instant compliance with the deadline, neither does Richmond oppose this happening. Counsel for defendant further advised that Richmond expressly requests that the United States continue to not access, share, disseminate, disclose, or otherwise transfer the materials covered by the court's order without permission from the court, which the United States does not object to. Okay, I think it's unopposed. There it is. There's the one. There's the footnote right there. It's unopposed. He put it on the word unopposed. Okay. Rule 6B1A of the Federal Rules of Civil Procedure provides that when an act may or must be done within a specified time, the court may, for good cause, extend that time, et cetera, et cetera. Good cause exists to extend the deadline by which the United States must comply with the court's order insofar as discussions between the parties continue that may alleviate the necessity of the court spending judicial resources resolving any dispute concerning compliance with the court's orders. So that these discussions may continue, the United States respectfully requests the deadline to comply with the court's order be moved to January 12th. The United States is not requesting any other modification or alteration of the court's order. Footnote 2. Consistent with the court's orders, the government delivered the single copy of Richmond's covered materials to the District Court for the Eastern District of Virginia on December 29th. So it's there for them to get us. So that's that's huge for whatever case they want to reference these materials or they want to get evidence from these Richmond materials. Sorry if y'all can hear my dogs playing with each other. It's now under seal in the EDVA, so they can file for a search warrant to access those materials. They can file for a filter team, all that stuff. So that's like secured. So the issues we have left are now that that's done. The issue we have left is that there's the original copies of Richmond's materials from 2017 when he volunteered his hard drive, and it turns out they may have kept his original hard drive and swapped it with a different one. And I'm going to have more about that in just a moment. And then we have the Arctic Haze materials, which they made all these copies of. So the question is, they were ordered to return to Richmond all of the copies that they made and all the derivatives that they made, sans any classified material. But as far as the forensic things go, they can't delete it off the forensic image disk. So now they want to work with Richmond, but now we have a substantial, like a big portion of this has been resolved. Now it's up to Richmond how he wants to handle these other things, right? And I don't think Richmond really cares that much about actually getting his stuff back. It's been 5 years. He doesn't need it. And he got it back then, right? It's a matter of his Fourth Amendment rights and the fact the government has all these copies of his stuff. And there's issues with that. And if we're being fair, and if we just take like any kind of politics out of it, how would you feel about the government possessing all of your iPhone data, all your email account data, a copy of your hard drive, and then making multiple copies of those things, and then being in various places at the DOJ or FBI? And they're just floating around. All that private information, professional information, privileged information. Let's say you're an attorney, or it's from your attorney. It's material seized from your counsel. You have rights over that stuff. So that is an issue to be resolved. But I think the main thing here, or one of the most notable things, is that the covered materials are now filed in the EDVA. But there's something more here that I want to get to, and that's the fact of this drive that they made a copy of and that they may have swapped out. So I'm going to turn now to my friend Dawson, because he saw my thread on the most recent update, the stuff I covered in the previous video in this series, and pointed out that this is huge. McCabe stole Richmond's hard drive in 2017. That's that's what this starts to show, that the fact that they figured out that, hey, there's maybe another copy of his hard drive and they may have swapped it out with something else and it has classified information on it and they're trying to figure out how many copies there are. Well, if we go back to 2017, it looks like McCabe stole Richman's hard drive. McCabe was fishing for what the swamp draining cases that Richman was helping Comey on were. And McCabe told the OIG that he gave Richman his hard drive back after deleting the Comey memos that McCabe illegally classified. Remember, he up-classified them. They weren't classified at the time that they were given to Richman, Fitzgerald, and Kelly. It was just after Comey was fired. But McCabe knew that Richman and Comey were onto him. And he knew that because these other investigations had started up. He knew that Comey was willing to go after Hillary Clinton, which I know is going to fly in the face of what a lot of folks have bought into. But that's McCabe and Hillary's lies about Comey. And yes, Trump feeds those things. Yes, he gives narrative cover to Comey. And yes, Comey says mean things about Trump. Whatever. Like, Trump also said mean things about Rubio, and look what's happening now. You can't go by that. You have to go by the documents and you have to go by the paper trails and these things and the actual events that happened. And the actual events that happened are that we know for a fact that McCabe interfered in multiple investigations against Hillary Clinton and her cronies. And we know for a fact that Comey and then later Ray launched media leak investigations into the leaks that McCabe and possibly others engaged in 2016 and 2017, trying to frame Trump as a Russian asset and undermine his first presidency. And we know for a fact that when Comey sent the memos to Richman about his meetings with Trump, they were not classified. And to the extent that one of them had some information that might be considered classified, Comey blacked it out. McCabe went on a scramble in June of 2017 trying to find who all Comey sent memos to, because McCabe was freaking out that he was busted and that he was going to be not just fired, but that he was going to be found out as Hillary's man on the inside of the FBI. And remember, he leaked in that Wall Street Journal article in 2016. He leaked through Lisa Page in a way that was trying to make him look good. That was the whole point of it, was to try and make him look like he wasn't an asset to Hillary and that make him look good, but it ended up backfiring big time. And then the OIG ended up investigating it, and he busted them because he got Lisa Page's text messages. And he caught McCabe in multiple lies. Well, as during all that process, as McCabe has just come into office within the first 6 weeks of him being there or less, he finds out about Comey sending these memos and God knows what else to Richmond. So he sends Strzok, I believe, and James Baker, I believe, over to Richmond to get his computer hard drive and recover whatever Comey sent him. And Richmond voluntarily turns those things over. But now we know that there is a strong reason to believe, as I covered in my previous video, there's reason to believe that they swapped out these hard drives and that Richmond did not get back the actual hard drive that was his. I thought I heard something from upstairs. All right, where is it in here? There you go. While looking around their offices, DOJ realized that there are quite a few copies of these Arctic Haze / Richmond materials floating around. And while Richmond and his counsel were reviewing the Arctic Haze search warrants, which they now have thanks to United States v. Comey and Fitzgerald's order, not Fitzpatrick, Fitzgerald's order, they realized something odd because now they're looking at the serial numbers on the hard drives. DOJ did not return to Richmond his original hard drive that he volunteered to them in 2017. They replaced it with another minus the Comey memo that was on it. Problem: Richmond did not give the FBI consent to physically seize the hard drive. Rather, the FBI was authorized to make a forensic image of it and delete the 4 specific documents from the hard drive and then return the computer to him. Now, just because they were given permission to delete those 4 Comey memos doesn't mean all 4 were classified. They weren't. None of them were. McCabe's team took this laptop, referred Comey to OIG for prosecution, which is, again, another thing that makes people think, oh, Comey's so crooked, he's a swamp creature, whatever. But concealed the leak from the FBI security division about the supposed leaks. And where he was interviewed twice by the security division or inspection division and lied to them about not knowing anything about the leaks when actually he was the person. While they wanted Richmond's hard drive, they never got the computers of Comey's other lawyers. This also confirms that the court knows that the 3 Comey memos were never classified. That was a lie engineered by McCabe. Identifying one classified on the hard drive that indicates that only that memo was Comey classified was actually classified, but it was up-classified later. This is important because Comey printed that memo and used a black marker to redact all the classified information from that memo, so no classified memo was in it when it was sent to Richmond. And this is the one that had some information that was from the State Department. The other memo that Comey's team classified, or that McCabe's team classified, there's another one that was up classified, and I've talked about it before. It has a bunch of redactions in it, and it's State Department information that's in there, and it's about another country, and I'm pretty sure it's about Russia, but I'm not 100% on that. So, the reason Dawson says this is huge, just to my understanding, and the reason I think it's huge, is that if Comey sent things to Richmond, information to Richmond or to his other attorneys, and that's still out there, and if he sent information to them that can be used to help prosecute McCabe, and there's multiple copies of it in all these different places in the FBI or DOJ, and then if now some of that is now under seal in the EDVA, then what's just happened here is that these items have been verified as lawfully seized and now lawfully maintained under seal by DOJ and the courts. And now DOJ can go and get a lawful judicial search warrant for specific evidence they want to recover from them. And if there's multiple copies, and if there's forensic copies, which it seems there are, that just makes it that much more credible. And the whole process, I'm not right about everything, but I'm right about a few things. And I still 100% believe that the entire purpose of United States v. Comey, which is currently under appeal, I still believe that United States v. Comey, that purpose was not about getting Comey. It was about getting documents. It was about getting evidence. And I've been saying it since the day that indictment came down. And now I'm like, finding this stuff in Richmond, I'm like, it's not just the Arctic H search warrant material, like the search warrants. It's the material they got from Richmond. And so imagine this, okay? Just imagine this if scenario, this what if scenario. What if one of Comey's attorneys comes forward, or what if Richmond does and says, hey, I have some information here I think DOJ would be interested in that has to do with McCabe and some criminal acts that I have information on. And then DOJ is like, oh, we got to make sure this matches the forensic copy that we have of this same material. And then they get a search warrant for it and they find out it does. Like all of these, there's just a few scenarios that come up that I'm like, there's some potentialities. And then the room, which we also learned so much more about. We got the actual story of the FBI skiff, the secret room, the hidden treasure trove of evidence that Comey buried from everybody. What you want to bet McCabe never had access to that room? Good times. All right. That's it for this update, this quick update. And I'll see you guys, and you'll see me in the next one. All right, thanks folks. I'm just putting this video together. I'm going to record this is my ending to this podcast episode. So, hope you're enjoying following the Richman case with me as much as I'm enjoying following it. It is at times a bit difficult to explain because it kind of got complicated there for a little while. And it's also, I mean, I'll admit, it's not the most exciting case I've ever covered, but it portends something that is quite exciting. And so there's this something about it that really has me. And for those of you who have, there's something super intriguing about it. And it has this potential to it. And I also just have this intuition about it. I have my intuition is telling me this is important. This is very important. And it has the entire time. So I hope you guys have that sense too. And I look forward to presenting to you whatever happens next with it. We might be at the end of it. And then the next most exciting thing that might come out of it would be learning that DOJ gets a search warrant for those materials, and then we'll see where it goes. And, you know, if you're looking for Comey to be indicted again based off material that's seized from Richmond, then I think you should also be pretty excited about how this has gone, because they can get a judicial search warrant for it. They can lawfully obtain those communications. They can get a filter team for them. They can argue properly privilege and get that privilege pierced if there is some evidence of crime or fraud or something like that. And then DOJ will lawfully have those communications and they can re-indict Comey. Now, will they be successful with it? I don't know. I have a lot of doubt about that. But if that's what you're looking to have happen, then you should also at least be satisfied with how this has gone. So, all right. Thanks for listening to this episode, and I look forward to making more of them. Appreciate you guys. Stay just human, and you'll see me in the next one.